I'm delighted to be here. This is my first look at this fabulous new place. My class was the class of 1962, which was the year, I'm sure, before your parents were born. If I'm one of the most illustrious graduates, I think you can also say I'm one of the oldest graduates of this law school with more certainty. It's great to be back here. It's great to see this new building. It's fantastic. This law school is deserving of not only the building that is here, but also of the quality of students that you represent. This is without a doubt a great law school. I've lived in England, the United States, and now Eastern Canada. But all I can say is that the legal education that I got here equipped me for lots of interesting work and experiences. And I can't thank the law school enough for that. And I know, I'm confident that whatever you choose to do, you'll be able to say the same thing about this law school that I'm saying some 50 years after my graduation from the law school. I also want to pay tribute to your dean, who has been a catalyst supreme in leading this law school with great distinction and with great achievement and great success. It has been a joy to see the growth and progress and success that is attributable to Dean Babinski. So congratulations to you, Madam Dean. Now, my topic is not exactly one that I can start off with lots of jokes about, because it's really not funny stuff. So when I say the topic is, the title is The Saga of Afghan Detainees. By the way, can you hear me okay? It's a saga because it's a long story over a short time, as will be evident when I get into it. The basic issue in my remarks is a standoff between Parliament and the executive, the legislature and the executive, over information that was desired by Parliament. That information was in the hands of the government. And the focus of the issue were documents that related to the transfer of Afghan detainees by the Canadian forces to Afghan authorities. Now, the Canadian forces were not the only recipients, if you like, if I can use that word, of the Afghan detainees. The forces of the alliance were also transferring these detainees to the Afghan authorities. The underlying principle of the issue on Parliament's side is that in a democracy, Parliament needs all the relevant information in order to keep the government accountable for its conduct of the affairs of state. That's a pretty important principle. A related point is the importance of public disclosure or transparency of government conduct as a general matter. Now, there are times when there are confidences that are recognized, or privileges that are recognized. Solicitor-client privilege, cabinet confidences, privileged. But apart from those, there should be transparency, and this was all part of the standoff between Parliament and the executive. On the government side, there is also a principle, and that is it should not be obliged to disclose information which compromises Canada's national security, national defense, or international relations, or is otherwise privileged, as I said, by solicitor-client or cabinet confidences. But it's important to keep in mind that this controversy that was boiling really could only arise under the way it did, a minority government. The Harper government was a minority government. Normally, if there was a standoff between Parliament and the executive, because there's no real separation in the Westminster model of government between the executive and the legislature, because the majority government is the majority members, this issue came on the floor of the House of Commons, then the government of the day would have said, no, we're not going to reveal those documents. We're not going to disclose those documents, because they would be unified and gathered together and say, yeah, we won't let the opposition get at this stuff. I think that would have been unfortunate, personally. But that is the reality, the political reality surrounding the issue. What I want to do, just give you some other background events about this issue, and then in the second part of my remarks, I want to deal with some lessons learned from this experience and some proposals to deal with similar issues in the future. So for background, what really, in many ways, started this was a series of events. The House of Commons had a special committee on the Canadian mission in Afghanistan. That was how our Parliament does operate, is through committees. And the Canadian forces, by that time this committee was established, had been active in Afghanistan for many years. Canada made great contributions. But then in the fall of 2009, there was a shadow cast over the Canadian involvement. And that shadow came about through the testimony of a man named Richard Colvin, a senior Canadian diplomat who was posted in Afghanistan and appeared before this committee, the House Special Committee on Afghanistan, and testified that the Canadian forces did not directly monitor the detainees, the Afghan detainees that they were capturing or detaining, and then not monitoring them after they were turned over to Afghan authorities. And he testified, Colvin did, that according to reliable sources, the detainees, the Afghan detainees, had been tortured by Afghan authorities as a manner of, quote, standing operating procedure. And if that allegation were true, that would mean Canada would be in violation of its not only international law, but also with Canadian standards for proper conduct. I mean, no Canadian would ever justify torture by Canadian officials in any context. So the committee, that touched off. Through that allegation, started to make requests for, let's see the documents that are going, how are these things being handled? What is the evidence that shows that the Canadian officials have been alert to this problem, and how were they being alert to the problem? Or were they just being blind to this issue of possible torture? And the government took the position, oh well, in the House of Commons, you don't need these documents, and they're privileged under the Canada Evidence Act. There's some provisions for proceedings, in court proceedings in particular. You can get certain evidence not disclosed, might be disclosed to the judge, but not generally, on the basis of national security, national defense, or the impairment of international relations. But the parliamentarians, rightly I think, didn't accept that, and they kept putting pressure on the failure to provide those documents. They called for a motion, which eventually was passed, for the government to produce the documents, to risk being in contempt. They didn't produce the documents because it was under the privileges of Parliament that they must follow that motion by Parliament to produce documents. This is a question, I have to say, right at this outset. It's not clearly decided, there's cases on it, there's opinion on it, But it's like many things that we inherit from the British, some of which is just wonderfully ambiguous. And because clarity sometimes can be an enemy of progress. I don't mean that in a silly way. But I remember one judge once said in the Second Circuit of New York, friendly, sometimes ambiguity can be quite, if you like, salutary. Why? Because people will draw their conduct on the line of below the line of misconduct. They'll be extra careful. And that was his example. Anyway, so Parliament got excited by this. The House, as I said, passed the motion 146 to 143, showing the minority situation of the government. Then the Parliament was prorogued, but the order for production still survived. Then I was out of the country. I got a call and was asked to be an independent reviewer of these documents. By that, I would be looking at these documents and then deciding. I thought it was the government authorities again or something. They're everywhere. Anyway, I would be releasing these documents for public disclosure. And I would be giving advice, actually, to the minister, saying, in my view, I think these documents should be disclosed. I thought about this. I was in Italy at the time, and I consulted with a couple of my colleagues at Torrey's law firm where I work, and we decided to go ahead. It was really boiling. It was probably going to end up being an election issue, and it was nutty to me to think we should find some way of dealing with this. The position of the government, no disclosure. The position of Parliament, full disclosure of everything. There had to be something in between. And that's what eventually happened. You had counsel, there's a parliamentary counsel to Parliament, very, very, obviously I've never met him, but I've read a lot of his stuff, and very competent. And he gave the argument for Parliament, citing cases, citing authorities, learned writers on the parliamentary system, saying everything should be disclosed, basically, and if there was something sensitive, then Parliament, of course, would be sensitive to that issue of disclosure. You can't obviously disclose military operations. I mean, there were Canadians being killed, and we had briefings on this when I eventually got involved, that being killed, civilians, not just military people. And the intelligence of the Taliban I don't want to go into details, but it was impressive. They found ways of getting troop movements, supplies and material movements, and then having these explosives, these homemade bombs, which were just absolutely terrible in terms of fatalities and injuries. So you can't just disclose willy-nilly. And then, but the government, after all this opposition, kept referring to me as this independent reviewer, and unfortunately, which has accompanied a number of my appointments to different things, the fact that I was going to be appointed didn't placate the opposition. They said, I'm sorry, he's not a bad guy, but that's not good enough. So they got after this battling of citations of principles and opinions and so on, they went to the Speaker and asked for a ruling by the Speaker. And the Speaker, in April of that year, basically came back with a ruling that I will summarize, first of all, by saying it was, I think, a very impressive ruling. And it weighed very heavily the importance of accountability for parliamentarians. There's no doubt of that. And said that there has to be some way of finding and recognizing the duty of accountability of parliamentarians to ask the government to be accountable by providing enough information, yet at the same time, there was a need to recognize and safeguard security and confidentiality. And then he said, I'm going to suggest to the parties to put in a mechanism to reflect those. And I'm going to give you some time to do that. And if you don't, within 2 weeks, I will issue a second ruling. So I was very impressed. I thought he had the right approach. Because, why? Because there were some important principles on both sides of the argument. So the second ruling never came about, because within that period of time, the parties got together, which was quite unusual, and had an agreement in principle. They called it an MOU, an agreement in principle, for the creation of an ad hoc committee of parliamentarians consisting of one member and alternate member from each party. Now, the parties that signed that were the Conservative Party, the Liberal Party, the Bloc, but not the NDP. The NDP said, we want all the documents. And that was their position, and they felt they would not sign that agreement. So the agreement, in effect, said the parliamentarians, they'd be given oaths, they had to get fingerprinted as part of this. They would be given all the documents to look at, and they could refer documents that they thought should be disclosed to a committee of arbiters, or a panel of arbiters. And the panel of arbiters consisted of 3 ex-judges. Former Justice Claire Leroux Dubé, former Chief Justice of this province, Supreme Court, Donald Brenner, and myself. And we were to get, if any one member of that ad hoc committee wanted something disclosed, they would send it to us. We would look at it, set up a system, a methodology for looking at these documents, and in effect, I'll tell you a little bit about that methodology in a minute. We would then decide, as arbiters, what would be disclosed publicly. So the ad hoc committee saw the unredacted documents in full technicolor. They would look at them and then say, we want these documents disclosed. The panel of experts, of arbiters, I should say, had to find some way, because the MOU, the memorandum, called for balancing national security, national defense, and impairment of international relations. We had to find a way of balancing that. And to balance that, we looked at the jurisprudence of the federal court, which is quite vast on resolving issues of disclosure, public disclosure versus confidentiality in those areas involving national security, national defense, and international relations. So, and then with the other areas that were not subject to this national security disclosure, solicitor-client privilege, the government would claim, or cabinet confidences. Those documents were not given to the parliamentarians. They were given only to the arbiters. And we would look at those to see whether or not solicitor-client was justified, the claim was justified, and whether or not cabinet confidence, and there weren't that many on cabinet confidences, was also justified. But here's the methodology we applied as the panelists. We applied a 3-step approach. We began with the presumption that redacted information should be disclosed in order to maximize transparency. That was a principle that came from the Memorandum of Understanding signed by the parties. So we were applying that. It wasn't expressed in those terms, but that's how we interpret it. The presumption is you disclose. If you don't want it disclosed, there's got to be a justification that will keep those documents redacted. In other words, the first step, presumption of disclosure. Second step, whether the presumption can be rebutted because of national security, national defense, or international relation concerns. And then even in that eventuality, that is, suppose you could rebut that it should be disclosed, there was a third step. Well, even if it is to be not disclosed, can you make a summary of it that will give some information about the matter without revealing the, if you like, national security, national defense, or international relations? So is there some means of providing alternate disclosure other than the full disclosure of the document itself? And that was the way we proceeded. And the committee, we met with the committee as we were mandated to do under the terms of reference of the memorandum signed by the leaders of the parties. Had many meetings with them, and that's how we proceeded. Unfortunately, this becomes why it becomes a saga. There's a dissolution of Parliament in March of 2011 because of the federal election. But by a dissolution of Parliament, as some of you will know, maybe all of you know, I certainly didn't when I was in law school. When you dissolve Parliament, what happens immediately is the members of Parliament cease to be members of Parliament. The ministers don't. The ministers don't, because you've got to have a government in place at all times. Canada can't be without a government. It has to conduct its affairs, but the tradition under the Westminster model is you conduct your affairs you don't get into big contracts, you don't get into, you try to avoid huge sea change decisions, that kind of thing. There's a tradition of just keeping the thing going, not making incredibly important decisions. So the cabinet continues, but not the members of Parliament, and all committees are automatically terminated. So that's what happened there. Now, what we did, we put our work together as quickly as we could. We finished our work, even though the committee was no longer reporting, but because we felt we should at least finish the job that we were given, and we turned the results of our report over to the three signatories to the Memorandum of Agreement. And of course said if the new Parliament wants to continue this operation, we will do what they would ask us to do. But to have done all the work we did and not leave it in a report would have been, I think, just an unfortunate turn of events. So we turned that over. It's safe to say the majority of things, the documents we looked at, were either disclosed or summarized in some way. So that, and we had 2,300 pages of documents that the committee referred to the panel, and we had 1,450 pages of documents that we gave as a priority for working with that priority. We had to prioritize some of these things. And we did all of that, we released it, and we also did a review of the majority of documents that were withheld under solicitor-client privilege and upheld all but a few of those. That is to say, the claim of solicitor-client was a valid claim. So that's exactly, it's an overview of what this was all about. It was an unusual set of circumstances, a minority government, 3 out of the 4 parties signing, not all parties signing, a group of parliamentarians, like the parliamentarians, the 3 of us, Justice LaRue Bay and former Chief Justice Don Brenner, we all had to get fingerprinted. It was embarrassing to get fingerprinted. Especially, one of the things of the aging process is that you don't get good prints, because over time the skin wears out, but I won't get into it. The other thing I want to say in all seriousness is that unfortunately Don Brenner died after one of our last meetings, just before we were finalizing the report. He died suddenly of a heart attack, and Claire and I paid tribute to him. We dedicated basically what we were doing to him. In his memory, he was a terrific jurist. He was a great leader, great lawyer, a great Canadian. And we were greatly aided and helped by his contribution, no question about it. So what do we learn from this? I think, people will say, well, it only arose in this minority situation. But it raises serious public policy issues, I think, for how governments in the Westminster system operate. Because there are issues that transcend partisan politics. It's not just the employment of troops that capture accountability issues. When a government is sending men and women over to in perilous situations, and Kandahar was incredibly perilous. We heard the stories about what they had to do and the checks and balances, and watching people who were working for the Allied forces, but were also working for the Taliban. And some of the stories just didn't hit the papers. Really, they were in dangerous circumstances. But there are other kinds of crises and national emergencies that raise concerns about how is the government handling the issue. Granted, you can't have full-blown disclosure on a minute-to-minute update kind of basis, but there ought to be some way of having a mechanism to deal with this in our country. That's a group of parliamentarians. The Americans have their system, the UK has their system, that are a little, I think, much more advanced than ours in this respect, because you do have to have that adherence to accountability. That's what makes a democracy in this deliberative parliamentary system. But there are no absolutes to that, and that was I think, the brilliance of the Speaker's ruling, of striking that balance, and the MOU that the political parties came up with. So I think, rather than leaving this as to be done on an ad hoc basis and ignoring it might not happen, and I would strongly recommend that there be a mechanism that could draw on the experience that was done in this ad hoc fashion and set up a committee of Parliament to deal with emergencies, to have a group of parliamentarians from all the parties, be sworn under an oath of secrecy, which they all took, by the way, the parliaments took, as I so mentioned, and then they will deal with these issues on an updating basis, and they would have independent staff, because if you don't give them the independent staff, they won't be able to carry out their functions. And as I say, precedent for this, it can be looked at in other countries. You'll hear, once in a while read in the paper, President Obama met today with the leaders of Congress on certain issues. Well, those are the kinds of briefings that go on from time to time under that system. But you see, in their system, they have a very strong separation of powers: the executive, legislature, and of course the judiciary. In our system, there isn't that, as I mentioned earlier. There is this relationship between the executive, the cabinet. They're all sitting as members of Parliament, and they are controlled. The government is, in effect, the party of the majority. But that doesn't deny, I think, the need. And I've done a paper on this, and I've made recommendations that I think could draw on the experience of other countries like the UK and the US and Australia, actually. The other thing that I think is important is to have enforcement of that mechanism. You can't have the parliamentarians sitting in these things, getting these briefings, and then trying to make political hay out of these things the way they do in normal day-to-day parliamentary debates. And there are ways of doing that. You can have contempt powers for breaching their oath, but you do have to have that enforcement. Because with the improper enforcement in place, then you'd get people looking at this sensibly and not trying to get into political, if you like, exploitation of the information. We know it's the duty of the opposition to embarrass the government. We know it's the duty of the government to keep information close to the chest. But in normal political, if you like, relationships. But this is unusual. These are extraordinary circumstances of an emergency or, as I say, in deployment of troops. We really have to come up with something that can work. The other thing I think it will, I don't want to push this too heavily, but what it will do is also add a little bit of civility to the relationship between Parliament and the government. Because if there's this trust, in a group of parliamentarians that be giving them up-to-date information on certain things, you know, it can take the sting out of over-the-top behavior that leads not just to questioning and accountability, but leads to what many would call a sort of incivility and really quite not very productive relationships in Parliament. I'm not saying that this will be a cure for that, but it might just be a little more respectful of each other's roles. This is an issue you say, well, you know, it's not, is it that important? Well, I really think it is important, because if we don't, and I'll just end on this note, when you're looking at these issues of security and accountability, it's not just looking after what parliamentarians want or what the government wants. It's really an issue in which all Canadians have an interest, and that is the proper functioning of our democracy. That's what it amounts to. Because if you don't have respect for the accountability factor, then you're not having what most people would call is an important element of a progressive democracy. So that's, to me, why I find the issue of great importance. Not just because if you overreact in disclosure, lives will be lost. That's really important. But on the, at the same time, if you underreact, then our government will not be held to the accountability standard that Canadians want their government to follow. Thank you.
Thank you very much for those remarks on a really timely and important topic. We do have some time for questions and answers, so you're all prepared, I'm assuming. Somebody will be momentarily. Did you want to call on people yourself, or did you want me to call?
You.
I'll call. Okay, question for Justice Arcady? Yeah.
Thank you for your talk. I was wondering if you could explain what impact it had on your work that the NDP didn't sign the MOU, if any.
Well, look, no, I will say this, if I would have been, I think the three of us would have been happier if all the parties signed. I have to say that. Did it have an impact? No, I don't think it did. But I don't, they took a position. I think they were also a little concerned about my involvement initially, who is this, am I just doing something as the spokesperson? But the first round was, I was to be the independent reviewer, and that didn't, get any Academy Award. So they were a little reticent about that. But no, I can't say it impacted, no. It might have impacted the dynamic if they were there in the committee. I don't know that, because each party met, by themselves, and then they met as a group. But remember, under the agreement, any one member could refer documents to us, and in many cases there were just one member of that whole group of people.
Thank you as well for your talk. My question is about Canada's international obligations around torture, and how you feel the courts might address the government's recent statements around torture being applicable in some cases, unacceptable.
Well, that's right. I mean, is this relationship to the newspaper story that was in the last day or so?
Yes.
Yeah, well, I happen to be involved with another commission of inquiry into alleged terrorists that emanated from the Arar inquiry relating to the three people that were, Justice O'Connor, who conducted the Arar inquiry, said they should be looked at, these cases, and I was the commissioner. And in that case, we did find evidence that consisted, that led us to conclude under the test that I came up with my colleagues helping me, that the Canadian officials were not complicit in the torture, but their actions, based on all the evidence we had, and we can draw an inference, to conclude that their conduct likely contributed to the mistreatment or leading to torture in Syria and Egypt. That was a conclusion reached by Justice O'Connor relating to Mr. Arar, based on a report made by the president of this university, Stephen Toop, who was engaged as a special advisor to Justice O'Connor. I can tell you this, after spending a week with the three individuals and their counsel and my counsel, a week, not at a retreat, we were in rooms, went through painstakingly what their evidence of torture was. We were able to conclude, and I would stand behind this, that they were tortured. We had independent assessments from other people who described the facilities down to the same level of detail that they got, and these were not public accounts that you could just read off and memorize. So any event, this is very big, because what is happening in the world of terrorism is that there are a lot of states are using threats of terrorism to torture. A large part of the Arab Spring are states that have used the threat of terrorists, and dissenters become terrorists. Therefore so torture is a big subject. All this is background to saying there's one no-no in torture. Torture is illegal by customary international law. It's illegal by Canadian domestic law. There's provisions of the code, you can't, not torture. Civilized societies do not accept torture, full stop. It is prohibitive, it is illegal. Evidence obtained by torture equally is inadmissible. There is no decent system of justice that would allow evidence coming from torture to be admissible in a court. So the question then becomes, oh yeah, well this is not evidence being admitted in court. This is now evidence, intelligence that is used by CSIS. Remember this, if I read the article correctly, this was the Minister Tays, the Minister for Public Safety, saying to the CSIS, Canadian Securities Intelligence Service, you can use this information you get from torture not from their torturing, but under a certain person who was in a country that does use torture. You can use that for intelligence purposes. The only thing I will say about that is that that may be a narrow looking at that question, because Canadians abroad, when they're, as these cases were involving Canadians, Arar was a Canadian, and the three I had were Canadians. There were also Syrian dual nationals. They were, once you are convicted, charged with a crime in a foreign country, you have a right under international law, the Vienna Conventions on Consular Relations, to get counsel advice from your country's consulate or ambassador. Well, my point here is that if a CSIS official learns of a Canadian being tortured, I think, in my view of things, there's an obligation on that CSIS official to notify Foreign Affairs and say, by the way, we've just heard of a person alleged to have been tortured. Maybe if you're using the information, it's one thing, but you don't want that person in CSIS to be quiet, not inform his colleague or her colleague in external affairs. That's not right. So that's a spillover of this point that's being made. One has to be careful about. Another example is that when you get much of the information out of the ARAR, out of the inquiry I conducted, is the sharing of information. Terrorism demands nations share information. And some of the nations we have to share information with don't have our values of human rights and protections and freedoms that we have. We're not perfect, but we've got a lot of them that are important. And if you start sharing information, the CSIS official says, aha, this person's been tortured, but then says to the United States, by the way, this person, we've got information that indicates he's a terrorist because he confessed, but doesn't add the qualification yet. He got that. He made that disclosure after being subjected to torture. There's a big difference. So then when you call him a terrorist, well, we think he's a terrorist, that's giving him, and most of them are hims, a taint and a label that can be dangerous, very dangerous to it. So I'm not enthusiastic about that bald approach unless there are these wrinkles that I'm talking about. Is that an answer to you?
We have time for a couple more questions.
Thank you, Mr. Justice Yakovich. I want to know whether you know if the three-part test that the three-member panel put forward, if it's been adopted in the jurisprudence. I have a...
No, that's a good question. He said the three-part test that we did on the panel, whether that has been adopted in the jurisprudence. If you look at the answer in Canada, it comes close to that in these proceedings in court under Section 38 of the Canada Evidence Act, where they're the same, which we applied in our deliberations, but we applied it in a kind of a different way, because we looked at. We were not under Section 38 of the Canada Evidence. We were under this memorandum of agreement. So we focused on interpreting what is the methodology looking at the memorandum of agreement. And we said there was a presumption of openness, disclosure, and transparency. I think that's a different matter. It may end up in the same way, but we put that in. So I can say to you as the first step, and then the second step was, if it's rebutted, notwithstanding that, can it be disclosed by way of summary? That's from the jurisprudence. So there's an overlap, but I wouldn't want to say that it's exactly parallel to the jurisprudence, but it's close to it. Good question.
Last question?
I
wonder if your staff on the panel included anybody with national security experience or expertise, and if not, do you think the future panels that you're proposing would benefit from that?
What we had was, we had a staff of lawyers, and two of the lawyers had worked in Section 38 cases, and we really were familiar with a lot of the jurisprudence into that section and in court proceedings, so that was really a boon. But before we started our work, we had very extensive briefings with representatives of the armed forces, representatives of foreign affairs, and representatives of defense, who really gave us a tremendously insightful, if you like, background exposure to the kinds of issues. Why is it important to have this not disclosed? And they would give examples. We got a really, I think, first-rate background. We didn't want to have them on our staff because they were working for the government. They don't work for us. But we were given, I mean, they were pros, and they were not trying to, cook the books and anything like that. But we had to invest a fair amount of time to get that learning, because you just can't go in there. And the lawyers are important, but as you'll find out, the law is necessary in a democratic society, but it's not sufficient. There are a lot of other things, and that's what we needed, that background from the experts, and we got a lot of it. It's a good point.
Great. Well, thank you again for your presentation. And I think we have a small gift that's going to magically appear from Simi. So thank you again.
Thank you
We're very
much.
grateful.
Thank you.
And thanks to each of you for taking the time.
Thanks very much.